I think what is clear from the comments made by Mr. Justice Chan, that if a bank wants to, down the line, rely on any form of exclusion clause in its client agreement, then it has to make sure that a particular financial product is expressly referred to in the particular clause. Now, the reason behind that is if something has been expressly mentioned rather than under a more sort of generic description of products, then it's very difficult for the court, when this eventually goes before the court, it's difficult for a judge to try and carve out, if you like, liability, because it's there in black and white that the judge is excluding liability in relation to a particular product. Now, interestingly, in the Standard Chartered case, again, that was quite unusual because the clause in question, the judge determined that actually only applied to high-risk investment products, whereas in this case, Mr. Lee's investment was a low-risk investment product, and therefore the judge struck it down. I think there's another important development on the horizon which I should mention in this context. That is, the SFC is bringing into force in June 2017. There's going to be a prohibition. It's something which is actually being introduced into the Code of Conduct, right, which will prohibit the inclusion of any exclusion clauses in a client agreement or other documents. Now, that's obviously very controversial. Now, it's slightly different compared to the suitability clause, because this is something which still remains, it's in the Code of Conduct itself, right? But saying that, you know, if an investor can show that there has been a breach of the Code of Conduct in relation to exclusion clauses, then that is clearly going to be helpful when an investor is pursuing a claim against a bank, if it can show that the bank itself has not complied with its own obligations under the Code of Conduct. Now, it remains to be seen at this stage. We've still got a long way to go, but you know, it's unclear whether the banks are going to take what's quite a drastic step of effectively removing all exclusion clauses from their client agreements. I mean, understandably, that's something that the banks and financial institutions will be very wary of and will be reluctant to do. So when this goes before the courts may actually take the view that even though there's these provisions in the Code of Conduct, that actually under certain circumstances it may be reasonable to include an exclusion clause, and that would be particularly relevant when the bank is providing advice and recommendations in relation to a professional and sophisticated investor. Now, of course, again, this has to be viewed in context. Even if an investor manages to persuade the court that an exclusion clause has been improperly included in a client agreement, and the court agrees with that and holds that it's unenforceable, that doesn't get the investor home, right? It just deals purely with the exclusion issue. The investor will still have to go over the hurdle of establishing that the bank has been negligent. And I think what is quite clear from Mr. Justice Chan's judgment, that will be very challenging, and it still will be, and will be particularly so if the bank can show that it had robust due diligence procedures in process, because that in itself can, you know, afford the bank a complete defense to a claim.